Hi, this is Mike Young, estate planning and elder law attorney in Walnut Creek, California. And I'm going to talk to you about not listening to your neighbors about Medi-Cal. But before I do that, I'd like to ask for you to please hit the subscribe button below, because when I make new YouTube videos, you'll get notice of them. And I hope you are getting some benefit from these videos. In addition, my granddaughter Edie, who's 12 years old, told me, "Now, Papa, you need for your YouTube videos to go viral." And I said, "Well, how do I do that?" And she said, "Papa, you use a nice voice and you ask people to please subscribe." And so that's what I'm doing. But if you don't want to, that's fine. So in any event, also, I'd like to let you know that I put on Zoom meetings on the second and fourth Thursdays of every month at 10 a.m. And on the Zoom meetings, I talk about various aspects of estate planning, advanced estate planning, probates, and Medi-Cal. So go to my website, walnutcreekelderlaw.com. I'll share my screen with you. Here's my logo, walnutcreekelderlaw.com. Go there and sign up for one of the workshops. They're interactive, they're fun, and people seem to enjoy them. So in any event, I hope to see you there. So people will tell me, they'll come in and they'll talk to me about doing their estate planning. Part of the estate planning we always discuss is Medi-Cal, Medi-Cal for a potential nursing home stay, and how we can get our ducks in a row in our estate planning documents with regard to qualification for Medi-Cal. And so clients will tell me, "Well, Mr. Young, I have been talking to my neighbor, my backyard neighbor, and we talk all the time, and she knows a lot about Medi-Cal." And I was telling her about our situation, and she said, "Well, you have too much money. You have too much money to qualify for Medi-Cal." So I don't know exactly how the neighbor would know that. But let's say I have a married couple, Bob and Mary Smith, and here's their estate plan. They have a revocable living trust. They have a home. Their home is in the trust. It's worth $1 million. And let's say Bob is the ill person who I want to get qualified for a skilled nursing, for a stay in a skilled nursing facility. And let's say Bob, just to use a number, has $300,000 in IRAs, and his wife, Mary, has $300,000 in IRAs. They can still qualify for Medi-Cal because IRAs, so-called qualified assets, are exempt. They're exempt. They're not counted as assets for qualification for Medi-Cal. So Bob and Mary can have all these IRAs. Here's $600,000. They can have more than that. Here's their home for $1 million. Otherwise, for an individual, if I'm going to qualify Bob, he cannot have more than $2,000, and his spouse Mary can have up to $128,640. And I'll link to some other YouTube videos where I explained how to transfer assets and gift assets to get Bob, for instance, qualified for Medi-Cal. If Bob is a single person and I'm qualifying him for Medi-Cal, he can have all these IRAs, in this case $300,000, but he can't have more than $2,000 otherwise. But again, California allows us to do gifting. The rules are complex. If you don't do it right, you can create periods of ineligibility for Medi-Cal. So always ask your elder law attorney before you do that. So the lady over the back fence who says you have too much money is wrong. The lady over the back fence who you should not listen to also could typically say that you make too much money. You make too much money to qualify for Medi-Cal. Well, it's not the issue. Making too much money does not disqualify you from skilled nursing Medi-Cal qualification. And in other YouTube videos that you've seen, I explain how you could, two different ways that you could go to a skilled nursing facility and then apply to have Medi-Cal pay for most of the monthly expense to the skilled nursing facility. So Medi-Cal will pay $10,298 a month to a skilled nursing facility. So, and they run, I've seen skilled nursing facilities run up to $15,000 a month. So with regard to making too much money, let's say we have this couple, Bob and Mary Smith. Again, I'm qualifying Bob for a stay in a skilled nursing facility. And we already said that Bob can have a home, he can have all these IRAs, Mary can have all these IRAs, but his income, Bob's income, no matter how much it is, goes to the skilled nursing facility. It's called a share of cost as against the $10,298. So let's say Bob's income from all sources, required minimum distributions, Social Security, whatever it is $5,000 a month. His contribution to the skilled nursing facility is $5,000. So whatever his income is goes to the skilled nursing facility as a share of cost. But the thing of it is, with regard to qualification for Medi-Cal, Bob will never pay more than the $10,298 as opposed to potentially $15,000 a month for a stay in a skilled nursing facility. And then Bob will get little exemptions from his income, $35 for incidentals and his Medicare Part B premium, basically. So if he's married, Mary gets to keep all of her income, no matter how much it is. So let's say Mary makes $100,000 a month, Mary gets to keep all of her income. Mary also gets a floor of $3,216 a month. So to the extent that Mary makes less than $3,216 a month, we borrow, so to speak, Bob's income when we do the accounting to Medi-Cal, subtract it from Bob's income, put it over on Mary's side of the ledger to bring Mary up to $3,216 a month. So with regard to the lady, your neighbor over the back fence, really there's no such thing as making too much money, unless you make a lot of money, in which case you don't want to mess with any of this with regard to Medi-Cal. The next misconception or things that neighbors say is that you don't want to get involved with Medi-Cal because you will lose your home. The state will lose your home if you die after having been on Medi-Cal. So as of, and this has never really been the case because we've been allowed to do planning and transfers of assets, including the home, which we don't need to do now. So we established the home as an exempt asset, and I'll link to one of my other videos where I explain how to make the home an exempt asset for qualification for Medi-Cal. But if your home is in your revocable living trust, when you die, the state cannot put a lien on your home, and it cannot follow a lien on your home because it's in your revocable living trust. So that's as of January 1st, 2017. So what the state of California has done is adopt the federal definition of estate, meaning assets that are probated through probate court. So your home is not going to be probated because we have it in the revocable living trust, and when Bob and Mary are dead, the home goes to the children without having to go through probate court. So likewise with other assets, your next door neighbor will say you'll lose other assets to the state. for recovery. And again, not the case. As of January 1st, 2017, only assets that are subject to probate, called a probate estate, are subject to a Medi-Cal lien. So another thing that I hear my clients say that their neighbors tell them is, forget about trying to get qualified for Medi-Cal because skilled nursing facilities never have any Medi-Cal beds. Well, there's really no such thing as a Medi-Cal bed. If the skilled nursing facility has signed up for Medi-Cal, the Medi-Cal program, and most of them have, I don't know of any around here who are not signed up, it's not a Medi-Cal bed, it's whether or not you have qualified for Medi-Cal so that the state will pay for a stay in a skilled nursing facility. And again, I'll link to one of my YouTube videos where I talk about how to go to a skilled nursing facility, 2 different ways that you might go, and then how to qualify for the skilled nursing facility. So go to my website, walnutcreekelderlaw.com, and sign up for one of my Zoom workshops, second and fourth Thursdays at 10 a.m. And you can also ask questions. Also, don't forget to subscribe. Hit the subscribe button below. So when I go viral, I will be able to tell Edie, my 12-year-old granddaughter, that I have gone viral. So thank you very much for watching. You can call me 925-256-0298, and you can email to me at lawyoung1@gmail.com. Thank you for listening.